My name is Marcus Quintanilla. I'm one of the leadership team of California Arbitration, Inc., what we call CalArb. It's a relatively new organization, but has quickly become the real community for international arbitration, in particular here in California. And it's my very great pleasure to present our entire audience with what is really, in my view, an unparalleled opportunity to actually talk to ranking leadership of all of the international arbitration institutions that I think have most relevance to the practice of international arbitration in California. So we have a lot to talk about today. I won't spend a lot of time with introductions. Let me just very briefly introduce each of you, and then also the leader of our panel today, Sudhi Tronson. So first up, and these are in alphabetical order, so no other meaning taken there, but that gives Mariel Dempsey pride of place. Hello, Mariel. She is the Secretary General of the Hong Kong International Arbitration Center. Before being at the HKIAC, she was the co-head of the International Arbitration Group at CMS, and she is qualified in both Hong Kong and Australia, and also serves as an arbitrator. So thank you for joining us, Mariel. Also with us is Abby Hawthorne, who is the Deputy Director for Arbitration and ADR in North America for the International Chamber of Commerce. Everyone knows the ICC is based in Paris, but I can tell you that their North America presence is alive and well under the banner of SIAC, and Abby Hawthorne is a big reason that they are so vital here on our shores. Third on my list of invitees is Janet Quiros, Director for the ICDR, the International Centre for Dispute Resolution, the international branch of the AAA. She is based in Houston, but was formerly at the Mexican law firm of Abascal, Flores and Segovia, a leading arbitration firm. And before that was Secretary General at CANACO, which is one of the most important arbitration institutions in Mexico. So thank you very much for joining us, Janet. Also with us is Kim Taylor, President of JAMS. JAMS is the largest private ADR provider in the world, and having its origin in Orange County, California, has already in just a very short time made huge inroads globally. And as I understand it, Kim, one of her primary remits is spreading the gospel of JAMS across the world. So welcome to our group, Kim. And lastly, we have Kevin Nash, who is sitting in very at the last minute for Adriana Uson, who is the director of the North America branch of SIAC, the Singapore International Arbitration Center. Kevin, we are grateful to have you join us, and you'll be able to provide, as will all our participants today, a little more information about yourself as our proceedings get going here. So last but not least, Sudhi Tronson is the real organizer of this panel. She is managing counsel at SDLG law firm in Silicon Valley, but Sudhi is so much more than that. I think there is not a club or committee or group that advances the profession in California that she is not a member of, in particular, the Licensing Executive Society in particular, the Silicon Valley chapter. She's a real expert in the area of IP licensing, and it was really in the context of discussions with her about IP licensing and some of the questions that arise in that context that this panel had its genesis. So it is sponsored by CalArb, but also the California Lawyer Association, ADR Committee, and the IP section, and the Licensing Executive Society. So without further ado, Sudhi, take it away.
Thank you so much, Marcus. And I want to again extend my gratitude to all of our distinguished panelists who are actually joining us from across the world in different time zones. So I really appreciate being up and early in the morning before probably the sun has risen. And thank you, Marcus, and thank you again for our hosts and the sponsors for the program. As Marcus mentioned, I'm an IP attorney. I come from an engineering and science background, so I have a very regimented thought process when I want to understand and analyze a lot of my transactional work. So I do a lot of patents and trademark work, but I also a considerable amount of my practice is devoted to technology transactions, from licensing to supply chain to joint development and so on. And as you can imagine, as transactional attorneys, especially when the parties are across different jurisdictions, internationally in particular, we like to use arbitration for a host of reasons. And in the experience and actually doing it for a living, I don't do the arbitration itself, but when it comes to the choice during negotiations between the parties, each party has one institution that they're comfortable with, they have used before, and often one party wants one, the other one wants another one, and our jobs as counsel a lot of times is really understanding, is there a difference? Sometimes it's not, there's no reason to argue about something when in fact there might not be a lot of difference, and then sometimes there is. So I had all of these questions, and I reached out to Marcus because I heard him talk for the first time 2-3 years ago on a panel, and I reached out to him, and he was very gracious, responding to my questions without billing me. And so anyway, this is how this thing came about. So what we're going to do today, by the way, is we are going to ask all the participants to please, if you have questions, put them in the Q&A, not the chat. And Marcus will keep track of those questions, and we'll have about 10-15 minutes toward the end to answer as best we can your questions. And if there's something we run out of time, we'll be sure to get back to you one way or another. We don't have handouts or slides for this discussion. This is more like a panel. And if there's any questions, please don't hesitate to contact Marcus and we can try and coordinate some responses to your questions. So the way I'm going to do the panel as the moderator is, everybody is going to be welcomed and is going to be encouraged on our panel to respond to the questions. And I'm going to just randomly pick different panelists as the person I'm going to first address that question to, but it doesn't mean that, and we hope that everybody else is going to join in and provide their responses to that as well. So one of my first questions is for each of our panelists, and I would like to start with Abby, please, as to what are the 1 to 3 unique characteristics of your institution that parties should be aware of when choosing such an institution to do the arbitration for them. So if you could be kind enough to elaborate on that, then I would invite everybody to jump in afterwards.
Of course. And I would like to start off by thanking Sudi and Marcus for making this happen. They put in a lot of work to organize this panel and to bring us all together today. So hopefully everybody who's watching can benefit from this resource. So at the International Chamber of Commerce, I think the first thing that comes to mind is that we are truly international. We have offices in New York, Paris, Abu Dhabi, Hong Kong, Singapore, and Sao Paulo. And what that means is not only are we handling cases all over the world, but we have people in your time zone, in your continent, in your area of the world to pick up the phone when you call and to have that local expertise that you want when handling cases there. So that's, I think, the first big thing that we have made a priority with as an organization. And our New York office is actually just hitting their 10-year mark, which is an exciting milestone we'll have coming up. Second, I would say would be our court scrutiny process. So I think we'll discuss this a little bit more in depth later, but when an award is finally written by the arbitrators, it doesn't go straight to the parties. It goes through an extensive scrutiny process, which means that that award that's given to the parties at the end of the day is something that is the most enforceable possible. You have those extra eyes and extra talented eyes reviewing your award before it gets to you. And finally, something that is a little different between institutions is that we use an ad valorem system for the cost of the arbitration. So that means that you know from the beginning what the cost of that arbitration will be for your arbitrator and for the institution. Obviously, your outside counsel costs are different, but you know from the beginning, or even at the time of contracting, you can go on our website and find out what the cost of your dispute is, which some parties like to have upfront. So those are three things that I think distinguish us and make us special.
Thank you. Thank you for that. So I'm just going to ask the rest of our panelists. Marielle, how about you? What does distinguish, or what are the 1 to 3 unique characteristics for HKIAC?
Thanks very much, Sudhi, and also thanks to Marcus. I'll see if I can get it down to 3. I think the overarching theme for HKIAC is our expertise in dealing with arbitrations involving Chinese parties. So we have a number of arrangements due to our status as a common law jurisdiction within China, with mainland China, that offer benefits that no other institution, or no other jurisdiction, I should say, is able to offer at this point in time. These include arrangements that on paper closely track the New York Convention grounds for enforcement of awards, but actually in practice provide a great deal of deference to arbitrations seated in Hong Kong when they're facing enforcement in the Chinese courts. The second main one is the interim measures arrangement, which allows parties to an arbitration seated in Hong Kong, run by an approved institution, to seek interim relief directly from the mainland Chinese court where the assets are located of the respondent usually, while the arbitration is still ongoing. So that seems to be providing a great deal of leverage for parties, and it's seeing increasing popularity. We've just had our 100th IMA application a couple of weeks ago. Unlike ICC, we also see one of our identifying features as a light touch approach. We don't scrutinize awards. However, we do take a very cursory view over them before they go out for obvious typos. Our approach is more aimed at making sure that the parties get the award as soon as possible. They usually, after we receive the award from the arbitrators, we turn around that award, and provided we don't pick up anything in our cursory review that needs major revisions, I should say, we usually get that out to the parties within 48 hours. So we see that as a benefit, but of course, in different circumstances, parties may be after different things. The next area that I think I would talk about is our position in the APAC region. We obviously are an institution that is largely focused on mainland China disputes. However, we're seeing an increasing caseload from places like Korea and Japan, and we think going forward that will probably be an area of growth. So if I had to pick 3, they'd be it. Thanks very much.
Thank you. Yannette?
Sure, thank you very much. I'm sorry, my throat is playing games with me today, so I'll try my best to be as clear as possible. And I also want to thank Sodhi and Marcus for the organization of this panel. I think it's going to be a very great resource for people to learn a little bit more from institutions and directly from the people that are, actually managing and learning about cases every day. As Marielle said, it's hard to go down to only to 3 things, but I will try my best on this too. So I think that the most important thing for me to highlight about the ICDR rules is that they are the ones that better comply or put together practices from both legal common law and civil law systems in order to provide the parties with advantages in the management of the cases. That we have recognized that exchange of documents is a practice that was creating problems in arbitration proceedings, which is a very US law or common law practice. And it was actually being problematic in some cases. So what we did, we put some guidelines first, and then included in the rules some ways to prevent that to be abused by the parties. And then obviously we are not denying the tool for parties that are commonly approaching this practice, but with a very limited way to do it. And then provide the parties with the benefit of using it, but also with the limits that are more beneficial for the arbitration proceeding. Same thing with writing witness statements, which are more common probably in civil law practice, but now they are parties need to comply with them under ICDR rules after our amendment in 2021. Also, we have the motion practice, the dispositive motion practice incorporated in the rules, which again is a practice that is not very common in civil law, but can benefit civil law lawyers in some cases. So we are actually providing them with the tool and helping them to learn how it works and help them to benefit from this practice. So these are only examples of how figures from both legal systems are complied in the ICDR rules to make them a truthfully international set of rules. Me as a civil law lawyer, it was very interesting to learn this combination and how they work in the practice. Another thing I want to highlight is innovation. As you probably know, the ICDR were the pioneers in implementing the emergency measures of protections and the emergency arbitrators tool. We were seen at the very beginning as, why are you doing this? Is this a real good practice? And then we've seen it actually is. Some other institutions haven't adopted them because they are really useful during the proceeding. We've also implemented the expedited procedures for cases that are under certain, threshold in the amount of the claims, so parties can benefit of a more expedited and proceeding and then have a resolution even at a lower price. And also our commitment to diversity and transparency. If you take a look into the amendments or the recent amendments to the rules, those were mainly related to be more transparent, give the parties a better idea of how our rules work, to get a better understanding of how we internally operate and why those practices are important for us. And in terms of diversity, which is a very, very important thing for us, we are obviously implementing that in our policy. We work in increasing the diversity in our lists of arbitrators, which is another, specific formula that the ICDR created a long time ago in order to give the parties more control over the selection of the arbitrators, even when the institution is helping them to make that selection. So, I mean, I can keep going and going, but I will stop here and obviously open to interact again later.
Thank you. May I ask you, Kim, about JAMS? What are the 1 to 3 top characteristics for JAMS that you think are distinguishing?
I always talk about, when I'm asked this, I tend to just always go back to sort of the foundation of our organization, which is the really high quality neutral panel that we have. We are unique in that the people that are on our panel are work exclusively with JAMS, although they do conduct proceedings under other in concert with other arbitral institutions, but we manage their practices for them exclusively, and they do this full time. So they are dedicated to arbitration and mediation as their entire profession, and that gives them, I think, a specific expertise in dispute resolution. They're familiar with cross-border matters. Many of them handle those regularly. They're familiar with both civil and common law, often have very deep specialty industry-specific expertise, which is often very valuable in resolving cases. And we really emphasize as part of our recruiting and due diligence and onboarding and training the importance of fairness and integrity and neutrality. And so I'd say that that's probably our number one distinction and something we're very proud of. We also have very experienced long tenured case management associates, many of whom are attorneys, and are very specialized in the administration of arbitration matters, both domestic in the US and also cross-border matters. We pride ourselves on having consistent, high-quality administration wherever the matter is being held. Last year, we administered over 23,000 matters across the globe, so we have very deep expertise. And then I guess the third, and I'm sort of challenged, like my colleagues here on this panel, to just identify three, but that was the remit. So I would say that we pre-pandemic would say it was that we had very purpose-built facilities, and in locations, specific locations, we had them set up for specifically to handle international matters with things like translation booths in them. And as the world has evolved in the face of a pandemic, the fact that we have long valued innovation and investment in technology has really served us well. So we have in all of our facilities very sophisticated systems to allow for administration of arbitrations, not only in person, but also virtually, and as we're seeing more commonly, in a hybrid manner. So, and we're continuing to invest in that as we come out of the pandemic, and that this virtual environment is just de rigueur for everyone in the world these days. We're also looking at ways to get and incorporate tools for automation and the use of artificial intelligence and other technologies to make a better experience for everyone.
Thank you. I'm going to now turn to our representative from SIAC. Kevin, would you be kind enough to give us your input?
Sure. Thanks, everyone. Good morning. I have to step into the very big shoes of Adriana Husan, who is our head of Americas. So she's based in New York, and the Americas office is one of SIAC's 5 overseas offices. I think what's unique about SIAC is that SIAC has really become a bridge between the Americas and Asia. So we're a global institution that just happens to be based in Asia. And when I look at the arbitration map, what I see for SIAC is that we've had around 700 American parties in the last 3 years have chosen to resolve their disputes at SIAC. And then more broadly, in the past 5 years, we've had parties from 106 jurisdictions. So that's what you see when you look at the economic corridor, is that lots of parties are choosing to resolve their disputes at SIAC. And it's important for us as an institution based in Asia and for American parties is to really be able to look at the enforcement in Asia. So similar to ICC, we have the scrutiny process. So every award that's issued in an SIAC arbitration is reviewed and scrutinized. And so we might be looking at, say, an award that is going to be enforced in Vietnam or Indonesia. We have that track record of enforcement in these jurisdictions, and we understand the procedural requirements for enforcement. To the extent that you can be sure that it's going to be enforced in the jurisdiction of the respondent, of course, it could be enforced anywhere where there are assets. But I think that that is really the key value add for SIAC, is that bridge between the Americas and Asia.
Thank you. I'm going to keep you on the hot seat, Kevin, and
Sure.
ask you the next question. So, by the way, we have taken note that there are some questions in the Q&A, and we ask a little bit for your patience so we can get through some of the key questions, and your questions may be answered by that time, and if not, we'll promise to address them before we end. So there's a lot of times in a lot of transactions, we're talking about mediation, arbitration, and so on. So what is your approach? What is SIAC's approach to integration of mediation and arbitration? And do you do that at all?
Yeah, so there's sometimes there's some senior arbitrators that say that in the first case management conference that the arbitrator has a duty to ask the parties whether they've explored mediation or amicable resolution. So we actually included language to this effect in the draft 7th edition of the SIAC rules, partly to get the conversation going, whether this is something that tribunals should be doing. I think a more interesting question is whether institutions should be doing it as well. So I'll give you an example. I think that the portfolio of SIAC, we actually have disputes ranging from about $2,000 to around $6 billion. So if I receive a notice of arbitration and I see that the clause provides for a 3-member tribunal and the sum in dispute is USD 2,000, should we proceed to mechanically constitute a three-member tribunal that is, of course, going to result in some costs and an arbitration maybe of 8 months or 10 months for this $2,000 dispute? Or should we, when we accept the case, ask the parties whether they've considered the possibility of mediation, and would they wish to, by mutual agreement, have arbitration at the Singapore International Mediation Center? So I think that's an interesting part of arbitration in 2023, is that you have many more tiered mechanisms. It's not as simple as just mediation, adjudication, or arbitration. It might be mediation, then arbitration. What SIAC has that's very unique is this ARB-MED-ARB protocol. And I think at one point I was at a mediation conference and I decided to start my intervention by asking, why are people not using this more? You should be using this more because it's very low risk. So what you have with ARB-MED-ARB is you avoid that academic issue with mediation, then arbitration of whether or not there's a dispute from a New York Convention standpoint. You lock in the commencement date of the arbitration so you don't run into a limitation issue. So how it works, we have this joint protocol with the Singapore International Mediation Center, which is our sister organization. So notice of arbitration, response is filed. We constitute the tribunal. The tribunal is then constituted, stays the arbitration, and then it goes over to mediation at the Singapore International Mediation Center. Almost always, I think, or every time, it would be a different mediator. And then if the parties are able to resolve their dispute, you have a standing tribunal that you can go back to, and then you can give effect to that mediated agreement in the form of a consent award. But I think more importantly, if you're not able to reach a mediated agreement, you really haven't spent that much time on the mediation. It might be a one-day mediation. You find, okay, parties are not able to resolve their disputes. Let's go back to this tribunal that's already up and ready. We've also seen in certain instances that there will be a settlement after the mediation. So maybe the parties are a bit more realistic about the issues. So in the ARB-MED-ARB protocol, our settlement rate is around 75%. I think it's even higher at the Singapore International Mediation Center. And I think it works equally good for those very small value disputes or also for those big mega disputes.
Great, thank you, Kevin. Abby, how does ACC handle that?
So similarly, we try to be a one-stop shop. So when parties have tiered clauses or otherwise at some point in their case are interested in mediation, our ADR center can step in and provide those mediation services. Recently, we've been delving into that med-ARB space that is so hot right now. And we actually just published a report, which is our guide for facilitating settlement in international arbitration. That is an in-depth look at kind of the state of play right now with arbitration and mediation, and seeks to act as a guide for parties, arbitrators, and counsel in this space. We've also considered mediation throughout in our note to parties and tribunals, and that's something that we think we'll see more of in the future, and have been tooling our processes accordingly.
Marielle, how about you?
We have an established med-ARB, well, we don't have as an institution, but in our region with China, being such a proponent of mediation as it is, we see quite a few cases at our centre that have these med-ARB clauses. One of the things that we have encountered in practice, and this is a product of the arbitration ordinance in Hong Kong, is that changing hats halfway through the process is very much constrained by what the applicable law says. And in Hong Kong, it says if you decide to put on the mediator hat halfway through an arbitration, anything that you learn from the parties in a caucus, should the mediation fail and you go back to arbitration, will have to be disclosed to all parties. So I mean, this is not an institutional perspective on this, but I was actually arbitrator in a case where we went to mediation in that manner halfway through. And one of the things that we all became attuned to in that process was that we had to be very, very careful about how we conducted the mediation, because it would impact on what we then would do in the arbitration should the mediation have failed. What we ended up doing in that case was just agreeing with the parties that we actually wouldn't caucus. So it was everyone was in the same room together. Everyone was discussing everything. It was essentially more of an assisted negotiation than anything else. But it did give us comfort that when we went back to the arbitration and it did fail, that there was nothing there that we were worried about having to disclose. So that's not really the institutional perspective. We see it quite a bit, but this is just sort of a reminder to everyone, if you're looking at MedArb, have a look at the law as well, because there may be things in there that will constrain what you're able to do.
Great, thank you. So I'm going to ask Kim if you can elaborate on that. Some of these are such critical questions that I would definitely love to have everybody answer some of these key questions.
Absolutely, and we sort of take the approach that we take the contract as it's presented. So the parties have agreed to a process, and we're going to honor that process. And if there is a stepped clause that requires mediation in advance, then that's something we'll encourage. That said, I think that Kevin raises a good point that there is a role, I think, sometimes for the institution to perhaps say separate from the arbitrator. I don't know that it's the arbitrator necessarily who should be doing that, but the institution might have a role at a point in time to say, you know, if the parties desire a mediation, we can certainly, you know, arrange that and help to facilitate that. There are definitely risks with the arbitrator stepping into a different role and putting a different hat on, and that we encourage appropriate sort of disclosures and waivers of the parties. We don't have a law similar to Hong Kong in our jurisdictions, but there's still risks that the process could be tainted if the arbitrator goes from being an adjudicator to a facilitator and then back to an adjudicator. So we have guidelines for our arbitrators to follow in the event that the parties want that. Obviously, we are here to get the parties out of conflict. So if that can be through mediation, all the better. And we also see that many arbitration matters do settle in advance of the hearing. And I think that's typical with litigated cases as well. So if there's a role for the institution to help to facilitate that, then I think that is something that we ought to look at.
Great, thank you. And how does that get handled at ICDR?
Yes, so as part of the amendments we have in 2021, we included in the rules Article 6 regarding concurrent mediation. So right now, everybody that incorporates ICDR rules in their arbitration agreement, they are basically agreeing to open a concurrent mediation case when they start arbitration. Parties obviously have the chance or the opportunity to opt out to this rule, but within the arbitration rules, it's an opt-in unless they do it otherwise. And let me just talk a little bit about how it works in the practice. So we have an administrative conference, which is another very peculiar practice in the ICDR. Before we constitute the tribunal, we have a conference with both parties just to discuss administrative issues, to explain how the rules work, if they have any questions about how our system works or anything like that. We address all of them during this administrative conference. And the main purpose is obviously discussing about the constitution of the tribunal. But another topic that is covered in this conference is mediation. And just as Kevin said, the institution takes an active role on proposing the parties to open this concurrent mediation case. This would be, as I said, a separate case. It's going to be a different case from arbitration. So meaning that we will appoint a mediator, which is not the arbitrator in the proceeding. We are in the initial thought is that those will be separate neutrals and separate roles. So, and we obviously encourage the parties to do it. What I normally do in my cases is that I invite the parties just to open this concurrent case, receive a list of potential mediators. They are probably not ready to mediate at that stage of the proceeding, right? It's too early. They want to learn more about the proceeding. And we can do that later, but it doesn't hurt just to have the list there, just to take a look at the names and just consider the option. So that's what I offer them. And then I follow up with them during the course of the proceeding to see if at any stage mediation makes sense. So we can just proceed with mediation, as someone just said, have a one-day mediation and see what is the outcome of that. Perhaps an agreement of the dispute, a settlement of the dispute, or just an agreement on certain parts of the dispute, which would obviously narrow the scope of the arbitration, and obviously save money to parties. So that's basically the idea on how we do it. If the parties decide that mediation does not make sense, we just close the concurrent case and we proceed with arbitration with no delays in the arbitration proceeding. Another thing I want to talk about a little bit, it's one thing we have recently launched in our cases is called the settlement tool. And what we have now, it's we are managing our cases with a electronic platform where the parties can access their cases, take a look at all their documents, track the events, make payments online, select arbitrators online, do several things online. And part of all these tools is this settlement tool, where the parties are able to make offers to the opposing party, set a deadline on that offer, make the other party look at the offer, perhaps accept it, make a counter offer, and then, see what comes out from that. That is something that the parties arrange between themselves through the system, which is very useful. We don't have too much, participation on that, but obviously if there's an outcome after those offers, we will obviously track that and help the parties to get a resolution. As Kim said, we are in the business of helping the parties to get a resolution. So that's our first and most important purpose in all of this.
Thank you, because a lot of times we do our best to put all of these what if scenarios in an agreement that has arbitration. But you can't think of everything up front. Plus, a lot of times, to cover everything takes multiple pages, and that kind of scares a lot of people if you have too much on any particular topic. So it's great to know that there are other mechanisms in place if the parties have failed or haven't considered to put some of those considerations in their agreements to begin with.
Hey, Sudi,
Yes.
were you going to continue on the point about mediation and the way that the institutions are handling and incorporating mediation? Because there's a really good question actually from our listening audience that I'd like to get everyone to chime in on if they can, just briefly. So where there have been these tiered dispute resolution mechanisms requiring perhaps a mediation phase before arbitration, the question is, does the institution require some kind of prima facie showing that the mediation, let's call it condition precedent, has been satisfied? How do your institutions handle that issue?
Very good point.
I can start if you want.
Please.
We get this all the time, and I mean it's a common objection. And just to go back to my previous point with these tiered clauses, they're quite common in this part of the world, so there's often an issue about that. We will take a prima facie view, and that threshold is quite low, and that's very transparently communicated at the centre. And provided we get over a sort of de minimis standard that it appears that attempts have been made, or if one party simply asserts that attempts have been made, as a general rule, and do not quote me on this, there are many fact-specific circumstances where this will not be the case, we will pass this decision to the tribunal. And indeed, if you look at the jurisprudence coming out of the Hong Kong courts in recent times, that is the general approach of the courts as well, that deference should be given to the tribunal rather than another body when looking at whether conditional or preconditions to arbitration, whether it be mediation or even something else for that matter, that should be the matter for the tribunal rather than anyone else.
And I'll just chime in that I think that's exactly right. And the last thing we want to do is allow something like that to derail an arbitration from moving forward. And we take as much of a hands-off approach on those issues from the tribunal point of, or the administrative point of view, and get those questions of fact in front of an arbitrator to decide. But we have seen situations where that can become a litigated matter unto itself at the commencement of an arbitration. And so we do our best to try to, again, low threshold for prima facie evidence of an attempt, and then off to the arbitrator it goes.
if there's any other differences in the approach from our panelists, please chime in. If not, we can move on to the next topic.
I think
Same
the
for
only,
SIAC.
sorry.
Jeanette?
Yeah, I would say that the only probably different way to manage it from our perspective, it's we would learn from both parties. It's not different. It's basically the same, but it's through a specific process. Is that we have the International Administrative Review Council, which is the administrative body that decides administrative issues in our cases, such as challenges to arbitrators, disputes on the number of arbitrators, on the locale, on the place of arbitration. And one of the issues that the IARC, as we call it, considers is if all the filing requirements have been met in order to initiate a proceeding. So this might be a topic for IARC to consider. If one of the parties says, we haven't exhausted mediation, we still need to go through that process, and then the parties would have the opportunity to present their arguments on this topic, and IARC would make a preliminary decision on it, and then leave it to a final decision from the tribunal once appointed, if that's needed. Another thing I think from the administrative perspective, and in order again to help the parties to move forward with the proceeding, is to offer them to conduct this concurrent mediation, which is very, very positive in these terms, right? We can have both proceedings managed at the same time, if that's what the parties want, and probably even offer them to conduct a mediation prior to arbitration. We can adjust and offer them other options if they are interested. But obviously we would try to make our best efforts for them to get an answer to their questions on this topic.
I can already envision another panel where some of these experiences and tips for example, for those of us who come from a science and engineering background, we like to have very precise yes, no metrics. Did it pass or did it fail? What are the metrics? How do you measure? So perhaps I can imagine another set of discussions on how to make those criteria more binary, yes, no, to make that decision process easier down the line, whether in fact people, fulfilled their obligation for pursuing mediation and so forth. So one of the things that I personally come across often is, are each of these institutions equally equipped to deal with all subject matters, or are certain subject matters more in your bag of competence, or for lack of a better word? For example, are there any particular subject matters that require special treatment? For example, let's say it's a patents or other forms of intellectual property. And how about business to business versus business to consumer type of actions? So there are two distinct questions, but I would love to hear from you on that. How about Abby, if we can start with you, please.
Certainly. I'm sure you'll see across all our institutions that construction and engineering, energy and transport are going to be very common case types that we see. At the ICC, we handle commercial and investor state. Cases involving state and state-owned entities make up about a quarter of our caseload, but we are not here in the game for consumer cases. We're just really, our system's not great fit for it. We did have cases last year that ranged from $9,500 to $27 billion in size. So within the types of cases that we see, there is a wide range. Cases seated in 71 countries, all over the map in that way, but we just do kind of stay away from those consumer cases, but everything else is kind of fair game. We work with all these different types of cases because of our system of, obviously, if the parties are choosing their arbitrator, that is the go-to, that is the default in our system. But if they need to ask us to appoint an arbitrator or recommend a list of arbitrators, we work with national committees all over the world to find the best qualified for that case. We don't have a set docket. In fact, arbitrators with JAMS and AAA and all of the institutions also work with our cases. So we work with whoever is best for that case and make sure we're giving it the attention it needs.
Right. Mariel, could you elaborate on that? Are there both from a sector perspective as well as type, like sector being, let's say, energy sector versus medical versus types being construction versus patents? How does your institution fare?
So it's interesting that Abby said, you know, as the first examples, construction and engineering and infrastructure, those kinds of things. We actually have far less of those than the ICC does. And I've had this conversation with your counterpart in Hong Kong, Shin, which is very interesting. And I think the ICC is probably in a slightly separate category because of the true global reach they actually have. But with the HKIAC, we see very consistently, or at least we have seen very consistently over the last 7 years, we've got sort of two key sectors that always compete for first and second place. And the first one is banking and finance, and the second one is corporate. So last year, 38% of our disputes were in the banking and finance sector, followed by corporate. I am fairly confident, and we're almost at the end of the year, can you believe it, that will switch this year, and we'll have slightly more corporate disputes than we do banking and finance. And I think it's always for the institutions that have perhaps more of a home base than the ICC does, I think that's always reflective of the industries that are prevalent in the jurisdiction or the jurisdictions that you're dominant in. And obviously in Hong Kong, it's banking and finance and the corporates. So that's unsurprising to that extent. Just very quickly on your point about the IP rights, we have I would call it a clarifying law that came in, I believe, in 2017 to clarify that IP disputes are arbitrable. They were arbitrable before, but the view was that that needed to be clarified, particularly in light of the advance of intellectual property disputes in Hong Kong and in China. Now, you're the IP expert. I'm not going to talk about whether or not certain aspects of patent disputes are arbitrable, but we are seeing an increase in IP disputes coming through the centre. This is mainly in the context of licensing, which is slightly clearer because it's inter-parties remedies rather than against the whole world. But I'll stop there because I'm about to go into territory I don't know that much about.
Okay. So Yanette, how about the ICDR?
Well, what we've done is that we've been trying to focus our different offices to different types of cases. For example, I'm in Houston, and I'm more involved with energy cases for obvious reasons. I'm also very close to cross-border cases with Mexico because of my, background. And we have, for example, designated Miami as the office contact with Latin America. We also have an office in Singapore, which they are actually managing our cases in Asia. So that's what we've been trying to kind of focus different offices to specific sectors. But as Avi said, we are trying to, our main effort is on getting the right people for the right case. So we have a specific set of panel members related to our main industries, so we can have a good balance of everybody that we need, but also keeping an eye on what the industry is requesting. You may also notice that, well, the AAA is a very big organization. We are the international arm of the AAA, and the AAA has different types of rules for different sectors. We have the construction rules, the consumer rules, the employment rules, the labor rules, and all of those are very focused on the different areas of expertise. But the ICDR, again, is like just the international arm, and we are focused on cases that are purely international. And I can share with you data if you're interested. For example, in 2022, we managed around 800 cases, purely international cases. And the most important industry was technology. We had 133 cases for technology, 55 of construction cases, and then followed by financial services, life science, real estate, insurance, entertainment, energy, transportation, and some others. So, but we are keeping an eye on which are, you know, the main market needs, but we also want to have a, you know, a very good balance again between industries and also between regions. We have to have people from different regions that can handle cases like in-house, if I may say.
Right. Kevin, what would you say with respect to SIAC?
In my view, all of the institutions represented here today are very well placed to administer all of these types of disputes. If you look at the portfolio, it is pretty wide ranging. One thing to me that's important for all institutions is the ability to administer new types of disputes. So what we're seeing a lot of in Singapore, and it could be SIAC, it could be ICC or any other institution with a Singapore seat, is a lot of the fintech, crypto, blockchain types of disputes. Every time I go to an exchange and I look at the terms and conditions, invariably it seems to provide for Singapore arbitration. So what's important for us as institutions and arbitration practitioners is to make sure that we are really staying faithful to those advantages of arbitration, because a new arbitration entrant might feel different about arbitration and the time and the cost for arbitration than, say, a big blue chip company that's been doing arbitrations for 50 years. And we also want to make arbitration accessible. So this is part of the reason why we've introduced a streamlined procedure that will sit alongside our expedited fast track procedure. So now we're making it go even faster at half the cost. So a streamlined procedure where you can have an award 3 months from the constitution of the tribunal. So I think in terms of, but from an administration standpoint, subject to the arbitrability of the subject matter, I think all of the institutions here would be very experienced at administering a wide swath of disputes.
Great. So in the interest of time, I'm going to, for the following questions, I'm going to again ask it to 2 or 3 of the panelists. And then if, you know, the responses are the same, you know, you can just nod your head or whatever, just so that we can get to more of the questions. So I'm going to ask next, Kim, what is your institutional default rule on the availability of interim and emergency measures in the process and from courts?
So we do have a process for that, and I don't have the rule in front of me, but that's something that in the most recent update to our rules, we incorporated that in there so that the parties have an option to seek interim relief as needed. And I can refer parties to our rules for that. I just don't have that in front of me at the moment. But it's definitely incorporated in our rules, and it is a process that's available to the parties.
Right. So, but do they just ask for it, or do you have a default in your process that you?
No, they have to ask for it. They have to request it, and then there's specific, very tight timelines for us to appoint an emergency arbitrator and to move that along expeditiously, so that they get the benefit of that emergency relief.
Got it. Abby, how about ICC?
I will just say we similarly have provisions, and we also, you know, if parties are seeking to go to court for a relief that they are seeking in a certain jurisdiction, they're welcome to do that. But if they need that interim relief through their arbitrator, they can reference our rules.
Got it.
Sudhi, before we finish this round out, just to kind of add a little bit of granularity to that question. So I think most of the institutions now have the availability of interim measures of protection or emergency arbitrators, in particular, emergency arbitrator provisions in their rules. But some may require the parties to opt in to emergency arbitrator proceedings in their ARB clause, whereas others may say, just by saying you've agreed to our rules, you automatically also agree to the availability of an emergency arbitrator. So by a show of hands, who in the group parties have to opt in to emergency arbitrators? Okay, so if it's a Hong Kong clause, if you want an emergency arbitrator to be potentially available, you need to specify that in the clause.
Sorry, just to clarify, I'm not sure I understood the question.
Sure.
No, sorry.
Okay.
You don't need to opt in the clause. You just need to invoke the process at the appropriate time, as is provided for in the rules. Yeah.
Okay. My question is opting into in the clause. does anyone require you to opt into the clause in a specific part of an arbitration clause?
Ours are incorporated into our rules, so if you select our rules, that becomes an automatic process that's available to you, but parties can opt out either in their clause or by mutual agreement after the arbitration has commenced.
Got it.
And I will also add some color. For us, there is a time date depending on the date of the contract. If the agreement was concluded before January of 2012, they will need to agree to the emergency arbitrator provisions. If it's after that, it's been part of our rules since then. So there might also be some time constraints.
Right.
Marcus, if I could add, and I always think it's important to remember that ICC effectively started this in '92 with the pre-arbitral referee, and then ICDR in 2006, sort of with the modern concept of emergency arbitration. But for parties, emergency arbitration has become a really standard part of arbitration, particularly in Singapore, because we have ICC, ICDR, SIAC all administering cases out of Singapore, and there's lots of emergency arbitrations. I think that it's become even more popular in the Americas because, of course, there is the very well-known Amazon Future Retail case that is wending its way through the Indian courts, and we got a very positive decision on emergency arbitration from the Indian Supreme Court. So I think that case is so high profile. I think now parties from the Americas are looking at SIAC and emergency arbitration and saying, hey, this is a really effective tool.
Yeah. Marcus, if I may ask, there's a couple of very on-point questions on the topic we just addressed, which was the type of subjects, including IP. So would you mind reading that and posing that to our panelists for clarification?
Do you have in mind the question regarding the Hong Kong and Singapore legislation?
Yeah, there are two questions from one of our participants having to do with IP issues and whether you can arbitrate them. And
Yeah. So, for example, as to the arbitrability of patent and other IP disputes, we understand, we just heard, in fact, that Singapore, or I believe it was Hong Kong, has recently passed a law clarifying that both validity and infringement are authorized to be arbitrated, even if that is not the law in the countries that actually issued those patents. So, are you finding it's really an open-ended question on how, in the different jurisdictions where you're focused, you're seeing that play out? Why don't we start with Singapore? Because I think Mariel already touched on this.
Yeah, similarly, Singapore clarified in the legislation of the arbitrability of certain types of IP disputes. And one thing that Singapore has really tried to do, and I think broader than arbitration, is really establish itself as a hub for IP. And I think you get a lot of ancillary benefits by providing this clarification. And so similar to the Hong Kong ordinance, I think that it's important from a user expectation standpoint to make clear that certain types of these disputes will be, excuse me, will be arbitrable, and you are getting the benefits, I think, of the overall ecosystem because of that clarification.
Any other comments on that?
I think because that's becomes, I think, very valuable, especially in those transactions where you've got both validity issues, infringement issues, and a whole bunch of commercial aspects as well. So thank you for elaborating on that. So what is your institution's default rule on confidentiality? Because a while back when I was looking at some of the different institutions and how they treat confidentiality was, distinguishing between, for the institution, between the parties, is it, what is your institution's practice on confidentiality? Do people have to definitely designate each thing that has to be kept confidential, or do you just have a default unless stated otherwise? Kim, if I may ask you first.
Yes, our rules require that unless it's otherwise required by law or the parties expressly agree otherwise, both the tribunal, the parties, the administrator, and JAMS will maintain the confidentiality of the arbitration. And it's always going to remain confidential unless all the parties consent to its publication or it's otherwise required by law in some way.
Mariel?
Thanks. With us, it's quite brief because it's not just in our rules, it's also in our statute. And it's very clear that everything is kept confidential, and there are, I mean, the parties can agree otherwise, but given the level of clarity and the fact that it's enshrined in our lex arbitri, it'd have to be a very, very clear agreement. We do occasionally, I mean, I think all institutions suffer from this. Awards get out, no one knows how they get out. But that's a slightly separate question. But we at the HKIAC take our obligations of confidentiality very, very seriously.
If there's any other differences from any of the other panelists, please chime in. If it's a standard protocol that everybody is held to that confidentiality, obligations, at least as a default, I'm assuming then that's the case for all institutions.
Yeah, I would just add in,
Yeah.
there is becoming a push for more transparency, I think, in the industry. And so we are working with Jus Mundi, as are some other institutions, to put in there, obviously, as long as the parties do not object, awards that are anonymized, pseudonyms, the whole nine, so it's not recognizable, but to try to give a little more transparency in the field. So that is something that's been more popular recently, and we'll see. That's kind of new, so we'll see how many cases start coming out and how many parties are okay with it in time, but hopefully that'll give us a little more body of arbitral awards to look at in the future.
Got it.
Sudi, if I could just jump in there, because there is a difference. We do work with Jus Mundi and others on similar projects. However, we do not publish our awards, even redacted. We had a long look at this, and if this is a topic that keeps coming up, but we have listened to the community, at least in Hong Kong, and there seems to be a strong push against it because awards can be identified even if it's heavily redacted. What we will do is publish our procedural decisions on things like joinder and consolidation and single arbitration under multiple contracts. So that's the middle ground. That's our contribution to transparency.
Got it.
Yeah,
So let me-
and
Go
I'm
ahead,
sorry.
please.
On our end, just as Abby mentioned, we also incorporated an amendment to the rules related to this commitment to transparency, and we are now publishing redacted awards with Jus Mundi. The parties have 6 months to oppose to that publication, so we think it's a very good time frame for them to say that they do not agree on that, and we just obviously will not do it. And that these would be applicable only to cases that are filed after March 2021.
Okay.
And just on that anonymizing of awards, which I do think can be a very valuable thing for the development of the law and so forth. The parties get an opportunity to view your anonymized version and decide whether it's anonymized enough, right?
Correct.
Okay. So, but there, in this question of confidentiality, there's a few different issues. One is the award. 2 is the responsibility of arbitrators and the institutions to maintain confidentiality. And then a third is the obligation of the parties to maintain confidentiality, which in some jurisdictions is just the law. And in other jurisdictions, like the United States, it's just not the law, okay? Unless you've agreed in your contract that it's confidential, you're free to run off to the newspapers. So how many of your institutional rules require parties to maintain the confidentiality of arbitral proceedings? As just by agreeing to your rules, you've agreed to confidentiality.
We do for our international rules. That's not necessarily in our domestic United States focused rules for the reasons that you suggested, Marcus. That's not the convention in the US. And you're right that, and it's also difficult for the institution to enforce the conduct of the parties with respect to confidentiality.
Yeah, and did you have a similar comment or another comment, Mariel?
That was just me raising my hand to say that our institution does put that obligation on the parties.
Okay.
Yeah, and same for me, and even witnesses. If you take a look at Article 40, it names a witness's obligation to confidentiality as well.
Okay.
Same, SIAC.
Okay, so if I understand them correctly, everybody has that default for everybody, including the parties, unless the jurisdiction or the choice of law, or is it the seat is in the United States?
For us, it would depend on which rules are the matter is administered under pursuant to.
Okay. Very good. So now just moving to something that it is more administrative. So let's say you've got the arbitrators have submitted a draft award to the body. How long does it take for the institution to actually release that decision? Basically, how long from the time you start to, you get the arbitration award to actually be able to get it to the parties so that it can be reviewed? Is there a secondary review in place? How does that whole thing work?
And hey, Sudi, can I just add to that? Because there were questions from our audience on this as well. We know that there's one divide here is between the scrutinizers and the non-scrutinizers, okay? But I also suspect that there's a range of scrutiny within the scrutinizers. So for those of you who are scrutinizers, tell us a little bit more about how that process works and how long it takes.
Abby, can we start with you?
Sure. So we are definitely in the scrutinizer camp and in the very heavily scrutinizer camp. So kind of taking even a step back, after the last submissions in the case occur, so kind of the parties are done in their eyes. We have rules about if it's a sole arbitrator, they're expected to have the award to us within 2 months. If it's a panel of 3, within 3 months. And if they go far beyond that, we actually dock their pay. So this is something that's very important to us. Once it's in our hands, per the rules, we have to have the scrutiny process done within a month. And this process involves both the secretariat, which is basically the case managers who have been with that case since day one and have watched the award go through. They're looking at it for everything from typos to if there were claims that weren't addressed, if there are issues with calculations of interest, if the arbitrator is not applying the correct law, if the law that's applicable to the award, requires that every page be numbered or whatever the rules are in that local jurisdiction. That case manager, because of the reason they have that case is because they're probably in the country, they're a qualified lawyer who's used to those rules. They're going to go through with a fine-tooth comb and go through that entire award. After that, it goes to our court, which the International Court of Arbitration meets every week or two. And depending on the case, it goes to anywhere from 3 up to 100 individuals who are practitioners from all over the world, look at it, do that second level of review with that secretariat's report. So you have people looking from kind of way up high and also in the weeds of the case from day one. We are not here to say that the decision is wrong. We're not talking about the merits. Our whole review process is about procedural. And at the end of the day, we are only going to be questioning things that could deal with enforcement, for example. So we want to make sure that that award, there's no appealing your arbitral award, but we like to think that having just that second set of eyes does make sure that what comes out doesn't have any issues that are headaches later. If there are issues in the award, which is the vast majority of cases are approved subject to comment by the court, it then goes back to the arbitrator. They usually take 7 to 10 days, 2 weeks, somewhere in there to come back with that final award, and then that can go out to the parties. So it is a little bit of a process. So even after the arbitrator is done, it can take an extra month and a half, but we like to think that it's worth the time. And people who come to us and choose ICC, they're interested in that. And there's that trade-off.
Yeah, thank you. And by the way, if the others of you, and when you address this issue, also fold in like Abby did, your way of handling slowpoke arbitrators, because that's another question from our audience. Abby, you said you dock their pay if they don't get it to you within the time prescribed by your rules. But let's make sure the other folks get to address that component of the question as well.
being in the scrutiny camp as well, perhaps I can give it a try. So for us, and as Abby would know well, to me, our scrutiny process is the biggest value add that we have as an institution. It is what all the members of the Secretariat spend far and away the most of their day on, except you can't really do it during the day because there's too much email traffic and applications during the day. So it's more of a nighttime endeavor. And I'll just give one story that I think is old enough to show the value of the scrutiny process and how it actually works. So we had, I think, one of the most famous obstructionist respondents, so certainly my favorite respondent that I've ever seen in an arbitration, that was attempting to derail things, challenge after challenge against the arbitrators, the institution. The claimant's successful on everything. And it was a very big case. So costs were, I think, just shy of 10 million for the claimant. Now, the transnational tradition is the costs follow the event. The parties in this case had even went an additional step in the arbitration clause to provide that the unsuccessful party will fully reimburse the successful party. For some reason, when we were scrutinizing the award, the tribunal, I think, just wanted to get out of the case and decided that each side was going to bear its own costs. So we probably had 4 back and forths with the tribunal. And the important language in the SIAC rules is that we can draw the tribunal's attention to points of substance. And ultimately, the tribunal did decide that each side was to bear its own costs. To me, that was wrong, based on what the parties had agreed and that transnational tradition, but it's still the tribunal's award. So for ICC and SIAC, our job is to make it as enforceable as possible and make sure that the tribunal has satisfied itself on the decision. So we will certainly bring up substantive issues. And then at SIAC, the registrar has ultimate charge over form. So for instance, if a tribunal didn't want to have a dispositive part and just wanted to end the award, then I would not be able to approve the award. But I think particularly where SIAC operates in Asia, very important to have this scrutiny process. Marcus, to your question on slowpoke arbitrators, it's all part of, you're looking at the lifespan of the arbitration. You don't want to find any gaps where there could be delays. So it's like a tribunal that is slow to close the proceedings. So under the SIAC rules, it's 45 days from the closure of proceedings. That doesn't work very well if the tribunal takes 8 months after the post-hearing submissions to close the proceedings. So you, as an institution, have to make sure they're acting promptly. And just like ICC, there has to be consequences. So if you're slow, when I'm fixing costs, I would tax slow arbitrators. There would be a reduction in fees, and I will also tax a slow SIAC. So if we have been slow when I'm setting SIAC's fees, then I would reduce those as well.
I will just say that I'll start with the fact that our rules require that in most circumstances, the dispute has to be heard and submitted to the tribunal for decision within 9 months after the initial preliminary conference in order to try to realize the benefits of efficiency and cost savings. And then the final award should be rendered within 3 months of that hearing. Obviously, there might be extenuating circumstances or the hearing is reopened for additional briefing or evidence. And then we are more in the camp of scrutiny because our rules say that no award will be rendered by the tribunal until it's been approved by JAMS as to its form. Like the others, we're not looking at the substance, we're not relitigating the facts, but we want to make sure that it's in the proper form and has the most opportunity to be enforced.
Thank you.
Could I jump in as a non-scrutinizer just with a couple of points about slowpokes?
Yes, please.
This is all really interesting, and I think something, and I don't want to speak for other institutions, but I assume it's something that everyone struggles with. It's the point in time from which you calculate your relevant deadlines, which then determine whether or not there's delay. And we've been discussing that at HKIAC recently in the context of our rules revision. And as Kevin said, the closure of the proceedings is something that we also find problematic because particularly those arbitrators that are out to game the system, and not deliberately, but it's, you know, it's a common tactic. They will just postpone closing it and then they'll close the proceedings and we'll get the award 2 days later or something. Be that as it may, I think there's a very practical point in there that I don't think's been mentioned yet. We are very aware of the slowpoke arbitrators, and if they're nominated by a party, what we are now doing in some very extenuating cases where we've been aware of extreme delays in previous cases, we will ask them not just to disclose the usual disclosures and their availability, we'll also ask them about delays in their previous cases, and that will be communicated to the parties. So that's the party nomination point, because that's obviously in their control. Where we appoint directly, Obviously, if we're aware of someone who has been extremely delayed in previous cases, you know, in the absence of extenuating circumstances, as mentioned by Kim, we just won't appoint them. So there's a very practical aspect of that, which doesn't help the parties in the delayed case, but there is a bit of motivation there to keep your delays to a minimum.
Thank you. Marcus, before we go, go ahead.
I'm sorry, I was the only one missing. And I'm in the non-scrutiny camp, but I'm surprised that we do a very similar exercise with our awards. We certainly do a reform review. We want to make sure that the awards that we issue are enforceable. And probably the difference is that we don't run that award between any court or any other body besides the administrative body that has had contact with the proceeding itself. There's a couple set of eyes that reviews the awards in the ICDR. We ask the arbitrators to give us a draft at least 7 days prior to the date of issuance. And our time frame to issue it, which is 60 days, is pretty strict. So if arbitrators are managing ICDR cases, they have to be aware that the award is going to be rendered within that time frame. We obviously had exemptions, which we don't obviously are not in love with, but and in those cases, we definitely talk to the arbitrator and say, you know, we need to put your compensation in a little bit in somewhere where it makes sense to the parties. Our system is a little bit different. We charge the parties on hourly rate basis. So we work with arbitrators' estimates for the proceedings. And when they are exceeded in that time, we obviously question them. We review all the arbitrators' invoices that we receive in order to make sure that the time it's accurate, that the activities that they are performing in the cases are in line with what we have received during the proceeding. We have a very strict billing guidelines, which states what is billable to the parties and what is not. So the arbitrators cannot bill, for example, communications with the administrator or, you know, studying the rules. It's not a very good scene for practice and things like that. So we definitely take a look on that, and you know, there's a reason why we follow this philosophy or non-scrutiny of the awards. It's just because we understand that the arbitrators are the ones that know better the proceeding. They are the most suited to make a decision, and there's no reason for us to have another group of people reviewing what the arbitrator has already decided. But again, our form review and the review on the claims that were decided and all of that, it's obviously something we do and something we take care of.
Thank you. We have just a little bit time left, and I think for me, one of my burning questions still remains that I haven't asked, and I would appreciate maybe we can just speed up some of the responses in the last few minutes, is special jurisdictional or regional issues. I'm sure you're aware, you know, especially in tech and semiconductor and energy sector, there is especially a lot of interest in collaborating and working with other companies that may be situated in Taiwan, in mainland China, and the like. So are there any issues with arbitrations that are administered by your institution being, let's say, enforceable in mainland China, Taiwan, and so forth? Or is there any special tricks is the wrong word, but that's the best question word that I can come up with, of recommendations that you would have in order to mitigate any such challenges, especially if you're dealing with, let's say, parties that are in mainland China and or Taiwan. Mariel, if I may start with you.
Thanks, Sudi. I'll be very brief because I addressed this largely in my introductory remarks. So in Hong Kong, it's kind of the reverse. We don't have special hurdles. We actually have a facilitative arrangement, which is being used with great success. And just on the enforcement statistics, as I said before, the arrangement, the intra-country, inter-jurisdiction arrangement between China, PRC and Hong Kong largely tracks the New York Convention grounds. So you'll look at the document and think, okay, that's nothing special. The proof in the pudding is in the eating, because we do, to the extent possible, try to track our awards once they leave us and go to enforcement, hopefully not too often. And that's an imperfect science, of course, but we're aware of about 80 awards that have been sought enforcement in mainland China in the last 20 years. And of those, only 3 have been refused enforcement for what we would call questionable grounds. And all of those 3 were more than 10 years ago. So we do think it's gaining in sophistication and familiarity with HKIAC. And that's one of the benefits of the one country, two system, in that the practical implementation of how this is happening may not necessarily reflect the fairly standard grounds that are provided on paper. Just on Taiwan, in terms of they are also subject to an arrangement with China similar to what Hong Kong and Macau have, and that closely tracks the New York Convention grounds as well. So for those purposes, it's an interjurisdictional arrangement, but the practical impact is very similar to that with respect to Hong Kong.
Okay. Any of our other panelists would like to address that?
I would just say that I think that there's a lot of, from meetings that we've had, there's a lot of concern about it and a lot of fear in some businesses and industries. But as we just heard, the reality is that there is actually a lot of enforcement, and things are going in a positive direction. So I think less concern than some people might suspect when doing US-Asia trade, for example.
I would also add, and this is not a direct plug, but just for the sake of completeness, the approved institutions in Hong Kong that have benefit of the arrangement also include the ICC.
So as long as the seat for the arbitration is in Hong Kong, then doesn't matter.
Good counsel who knows these rules.
Right.
You'll be okay.
Very good. So since I believe India's recent opening to international firms happened, has that affected any procedural things, caseloads, and so on, as it relates to seats, for example, being in India?
Kim, are you? Sorry, you. Well, certainly at SIAC we have hundreds, thousands of Indian parties. Indian parties are almost always one of our top foreign users. So we actually did a survey, and you may be jinxing yourself that we have never had an award set aside in India or refusal of enforcement. Sometimes it will happen in the lower courts, but the Indian courts, I think similar to the Chinese courts, the track record with enforcement is very, very good. We actually have, I think that our Indian caseload is so high, so that we have 3 Indian qualified counsel, very busy Indian cases. I think what's very good about Indian arbitration is there's a lot more cases that are being seated in India. So I would still say that Indian parties will tend to choose a Singapore seat, but a lot more Mumbai, Delhi. And I think Indian parties are so comfortable in Singapore, even when there wasn't clarification on whether 2 Indian parties were able to, under law, choose a foreign seat, they were still choosing Singapore as a seat of arbitration. So very busy, very good arbitration jurisdiction. And you also have that trade channel with the United States. So we have a lot of disputes with an Indian party on one side and an American party on the other side.
Marcus, if there are no other responses, any other burning comments or clarifications in the last few minutes we have that we should address from the questions or otherwise?
You're muted.
Yeah, sorry. It was sort of glanced on, I think, by some of the responses, but not really hit head on. So in a situation where there's a sole arbitrator and the parties can't just agree on an arbitrator out of the blue, which they seldom do, I'd be interested to know your institutional process for picking the arbitrator. And this will have to be a pretty quick round.
I'll just start real quick to say that we implement a strike list process. So we have an intake team that's situated across our organization, and they're trained to look at the contract clause to understand the nature of the dispute, subject matter, whether there are any venue requirements, and to then complete a strike list of appropriate arbitrators for that matter. And then the parties go back and forth in a strike process to select the arbitrators. Pretty straightforward.
It would
Mariel?
be,
Oh, sorry, Yanette.
Yeah, Janet, you go first.
yeah, it would be the same. I mean, we created this list method a long time ago, and that's the way we're using it. In addition to that, we are now offering the parties to make their own search in our panel of arbitrators, so they can access basically our database and just enter their own needs in the system, so they can get names from there and perhaps discuss and agree on someone from our panel, which is our preference, definitely. And in addition to this strike and rank list, which is the normal method, we can also offer a reference list, which is not as strict as a strike and rank. They can, again, see this list of arbitrators that we have created for them to consider according to what we discussed during this administrative conference call, and considering the nature of the contract and the amount in dispute and all of that. And again, trying to make them agree on someone. And if that's not the case, we can go to the strike and rank list.
I'll be very quick. When we directly appoint, we have a list on our website in a practice note that it's 15 factors. Just to add a bit of sort of flesh to that, we look for the best person for the job, keeping in mind aspects of diversity, repeat appointments. Are we expanding the pool? Is this a good first appointment for someone? Have we looked at gender? Have we looked at ethnicity? Have we looked at age? And it's a very difficult process to describe, particularly in this kind of forum, but it is about getting the best person for the job. And someone asked me the other day if, we would put diversity above everything else, and that's a clear no. It's not diversity at all. It's all at all costs. It's just a very important factor in finding the best person for the job. And we see it as our job as an institution to expand the pool of eligible arbitrators that will then go into the system, hopefully, and be up for party appointments in a few years. So we take that role very seriously.
Very good. Well, I think we've got 2 minutes left. This was a very fast-paced discussion. I still have so many questions to ask, but I think we asked and addressed some of the key topics. I'm going to just open it up to our panel and see if there's any last-minute thing related to anything that you want to very quickly let the audience know as to why they should pick your institution, or if there's something else that you want to share, whatever it is.
I'll address the question that was raised earlier. I mean, I hope that this panel has shown everyone that, it's not about why you pick us. It's about having an informed choice about who to pick, I would say. And the question about Hong Kong, about the uncertainties there, it's very well made. There have been changes in Hong Kong in the last couple of years, and it would be blind and ignorant for me to assert otherwise. But at the centre, we have seen very little impact on our cases. We are tracking the number of cases that have arisen from contracts that were signed since the issues came up at the end of 2019 and thereafter. And our statistic for last year was 49.8%. We'll see how it goes this year. I actually don't have the figures to hand, but it's a valid question. And to the person who posed the question, I can only encourage you to come to Hong Kong and look at the prevailing situation, as you call it yourself. We had hundreds of people coming in last week for Hong Kong Arbitration Week, and what I've heard, they were pleasantly surprised. So I could only encourage more people to do that. Thanks.
I'll just say that I appreciate Marcus and Sue, you organizing this, and for CalArb for sponsoring it. I personally always enjoy collaborating and learning from my colleagues across the industry. So thank you for that.
Thank you.
And I would only add that, again, as Mariel said, it's just to make an informative decision. So you can have the tools and just pick whoever you prefer. And in addition to that, I would say sometimes we obviously talk a lot about our rules, which is our main, tool. But I would also invite people to learn about the institution and learn about their policies, their philosophy, their purpose, and all of that. And that may play a role in the decision-making process. I've been part of 2 institutions so far in my career, and I've learned that it's not only about the rules, it's also about the people that work there, how they do things, and that all all sorts of things. So just I invite people to approach the institution. I think I speak for myself, but I'm pretty sure we all have open door policy. I'm pretty open to have everybody come and ask whatever questions they may have, so we can, again, give them the information to make the better decision.
Well, thank you, everybody. This has been definitely very valuable to me as a practitioner who doesn't have your expertise. I just use you for my clients, and this has been very, very informative. And I hope that our audience also was able to benefit from the discussions. Marcus, any last minute things before we end?
I don't think so, just except to say thank you all very much for joining us. It really was a rare pleasure to have all of you on one stage, and thank you so much for your contribution to CalArb.